Hello friends, welcome back to our channel Legal Nexus. In today's video, we are diving into concept of strict liability, a powerful principle in tort law where a person can be held legally responsible for damages even without any fault or negligence. Generally, a person is liable only for wrong done by him intentionally or by negligence. Cases by law holds, but a person liable for the harm done unintentionally and without negligence. This form of liability was first formulated in the case of Ryland versus Fletcher liability or rule of strict liability. Ryland versus Fletcher. In this case, Fletcher was a lessee of coal mine. Ryland constructed a reservoir on the neighboring land of the coal mine to supply water to his mill. There were odd disused shafts under the reservoir which communicated with the coal mine. The water flooded to coal mine and damaged it. The court held that Ryland was liable for the escape of water even in the absence of negligence. Thus, the owner is liable for the escape of anything dangerous like waste, water, filth, stench, electricity, traction, engine, or even a motor car with petrol in it. In all such cases, the liability of the occupier is absolute. Ramnath versus Kalanath. The defendant constructed a dam in his land and damage is done to the neighbor's property. Here the defendant was held liable. For the rule in Ryland versus Fletcher to apply, it is essential that the thing causing damage must escape outside the area of control of defendant. If there is no escape, then there can be no liability under natural use of land. Things naturally attached to the land, act of God or vis major, wrongful act of stranger, plaintiff on fault, common benefit, and statutory authority. These are the exception to the rule in Ryland versus Fletcher. Natural use of land means playing cricket in the cricket ground is natural use of the land, and hence if anyone is injured due to the hit of ball, he cannot recover damages. Things naturally attached to the land. The rule is Ryland versus Fletcher is applicable only to things which a person keep in his land. But if damage caused by anything which is naturally attached to the land, then the owner is not liable. Act of God or vis major. This principle is applicable if by supernatural power like lightning, flood, etc., something escapes and causes damage, then the defendant is not liable. Nicholas versus Marshland is an example for this principle. The defendant constructed a dam and by violent storm, water flooded out and injured the plaintiff's property. The court held that it was an act of God and so the defendant was not liable. Wrongful act of stranger. If a third party wrongfully or intentionally caused any damage to the plaintiff, then the defendant was not liable. Plaintiff's own fault. If the escape is due to the plaintiff's negligence or own fault, then the defendant is not liable. Common benefit. It means if the escape is due to the consent of the plaintiff and it is for common benefit of both the plaintiff and the defendant, then the defendant is not liable. Statutory authority. If the law has authorized the defendant to keep dangerous things, then the defendant is not liable for the loss due to the escape of things in the absence of negligence. Municipal water tank, animal in approved circus, zoos, etc. Rule in MC Mehta versus Union of India. The Supreme Court in the famous case MC Mehta versus Union of India has laid down the following rule. A new string rule. As per the Supreme Court judgment, there are differences between rule in Ryland versus Fletcher and rule in Union of India. MC Mehta versus Union of India. The rule in Ryland versus Fletcher need non-natural use of land by defendant and escape of something from his land which causes damage. But rule in Mehta does not require these conditions. The defendant should be engaged in a dangerous activity, as the rule in Ryland versus Fletcher requires escape of thing which causes harm outside the premises. If harm is caused within the premises, then there is no compensation. Though the rule in Ryland versus Fletcher is only strict liability and it is not absolute liability as there are many exceptions for the application of the rule. But the no rule in MC Mehta is not subject to any exception and it is therefore absolute. Ordinary or compensatory damages will be awarded in case of Ryland versus Fletcher. Exemplary damage can be awarded in case of MC Mehta's case. Under strict liability, a person can be held legally responsible for harm caused by their animal, even if they took all precautions. This principle applies especially to those who keep wild or dangerous animals. Strict liability for damage done by animal was formulated in famous case May versus Burdett. The liability of the keeper of animals depend upon the knowledge of the dangerous character of the animals. Classification of animals. Animals are classified as following depending upon the dangerous characters of the animals. Dangerous animals or ferae naturae. Domestic animals or mansuet naturae. Dangerous animal. These include lion, bear, wolf, elephant, monkey, etc. A person keeping any of these animals must keep it at his peril. If the animal escapes and injures anyone, the owner is liable to pay compensation to the injured party. The animals are dangerous by nature. The injured party need not prove the dangerous character of these animals. Knowledge of their dangerous propensity is presumed. Domestic animals or man's with nature. In this category, animals like dog, horses, camel, cows, pigs, rabbits are included. These animals are considered harmless and their keeper will not be held liable unless the injured party proves that the keeper is unaware of its dangerous character. The following are the essentials to make the owner of the domestic animals liable for damages. The animals must be domestic animals. Its dangerous character must be proved that is known as scienter. The owner must have knowledge of the dangerous character of the animals. The proof of a single instance of dangerous character of animal is sufficient notice to the owner. These two cases are related to this principle, Cox versus Birdbridge. In this case, the defendant's horse grazing in a field got into the road and kicked a child playing there. As the plaintiff could not prove the scienter, the defendant was not liable. Fedron versus Harcourt Rivington. In this case, the defendant left his dog inside the saloon motor car. The dog used to be generally quiet. The plaintiff was walking near the car. The dog jumped over the plaintiff. The window glass panel was smashed and the piece injured the plaintiff's eyes. The court held that the defendant was not liable because the plaintiff had not proved the scienter. Further, the defendant was not negligent because he left the dog safe inside the car. Defenses available for this principle. If the animal escaped due to act of God, no liability attached to the owner. If the plaintiff is contributory negligent, the defendant is not liable. If the plaintiff undertakes the risk of keeping the animals, the defendant is not liable. If a third party lets the animal loose, then the owner cannot be held liable. In summary, strict liability holds a person legally responsible for the consequences of their actions, regardless of intent or negligence, whether it is dealing with hazardous activities, defective products, or dangerous animals. The law ensures the victims receiving justice without a burden of proving fault. This principle plays a crucial role in promoting safety and accountability in society. If you found this video helpful, don't forget to like, share, and subscribe for more legal insights.